Louisiana is unlike any other state in the country when it comes to its legal system, and that extends to habitability law. If you're a landlord in Louisiana, the first thing you need to understand is that Louisiana operates under a civil law system based on the Napoleonic Code, while every other state uses the common law tradition. That distinction affects how habitability obligations are structured and enforced. Louisiana's landlord obligations are found in the Louisiana Civil Code, primarily Articles 2682 through 2729, which govern the lease of things. Under Article 2682, the lessor, that's the landlord, is bound to deliver the thing in good condition and to maintain it in a condition suitable for the purpose for which it was leased. Article 2693 reinforces this by requiring the landlord to make all repairs necessary to maintain the property in a condition fit for its intended use. Under Louisiana law, landlords must keep the structure in good repair, including the roof, walls, floors, and foundation. You must maintain plumbing and sewage systems in working condition, provide adequate hot and cold running water, ensure electrical systems are safe and functional, provide heating and cooling systems where applicable, and in Louisiana's sweltering summers, functional air conditioning is not a luxury. Keep the property free from conditions that endanger health or safety, including mold, pest infestations, and water damage, and comply with applicable local building and housing codes. Now here's where Louisiana's civil law system creates some unique dynamics. Because the obligations are rooted in the Civil Code rather than a detailed statutory Landlord-Tenant Act, the specific requirements are less granular than what you'd find in states like Massachusetts or Oregon. The standard is broadly stated: maintain the property in a condition suitable for its intended purpose, and courts interpret that standard on a case-by-case basis. Louisiana's climate makes certain habitability issues particularly pressing. The combination of heat, humidity, and heavy rainfall creates an environment where mold, moisture damage, and pest infestations are constant threats. Termites alone cause massive property damage across the state every year. Landlords who don't address moisture intrusion, ventilation, and pest management proactively will face habitability complaints. And in post-Hurricane Katrina and post-Hurricane Ida Louisiana, courts and tenants are highly attuned to these issues. When a habitability issue arises, Louisiana follows its civil code framework. The tenant should notify the landlord of the defect, and the landlord is obligated to make the necessary repair. If the landlord fails to act, Louisiana Civil Code Article 2694 gives tenants the right to pursue several remedies. They can seek a reduction in rent, called a diminution in price, reflecting the reduced value of the property. They can pursue dissolution of the lease, which is Louisiana's equivalent of lease termination. They can seek damages for any losses caused by the landlord's failure to maintain the property. And in urgent cases, they can make emergency repairs and seek reimbursement from the landlord. One thing that distinguishes Louisiana from common law states is that the tenant's remedies are framed in terms of the civil code obligations of the lessor rather than an implied warranty. The practical result is similar. Landlords must maintain habitable conditions, but the legal reasoning courts use to get there is different. Local codes matter significantly in Louisiana. New Orleans has its own detailed housing code enforced by the Department of Safety and Permits. Baton Rouge, Shreveport, and Lafayette each have their own local standards as well. In New Orleans particularly, the code enforcement system has been significantly strengthened since Hurricane Katrina, with more aggressive inspection and citation processes for blighted and substandard rental properties. Louisiana does not have a broad anti-retaliation statute comparable to what you'd find in more tenant-protective states. However, Louisiana courts have recognized that retaliatory evictions can constitute bad faith, and landlords who engage in obvious retaliation risk having their eviction actions dismissed. For the complete guide to Louisiana habitability laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for the rest of our state-by-state series.